everyone here knows Professor Sonbol, a leading scholar in Middle East history with a specialization on Egypt and in particular women. And so we'll be giving a talk entitled The Modern Arab Woman. I think we're all excited to hear this and can't wait to see what you have to say. So without further ado.
Thank you. Actually, looking out, you're either my friend or my student. So it's like coming home, so welcome. I must admit that the topic of the title of this lecture was Charles. He's the one who gave me the title. So if you don't like it, you should blame him. Anyway, okay, I'm actually going to read this paper because I want some reaction and some feedback. So bear with me as I do so. If I start talking, it's not going to be organized, so reading it's better. A couple of weeks ago, I actually gave this lecture at SOAS. I think it's been a couple of weeks ago. And the title of the paper is The Modern Arab Women, Discourses and Narratives. And in this lecture, I raise questions regarding the dominant paradigm that sees the modern woman as completely different than the pre-modern woman. And I was attempting a paradigm shift by trying to show that this is an artificial and not a real paradigm or a real way to look at the history of women. And I see that the need for the shift comes from not just because I'm a historian and I'd like to see a history based on lived realities, but also because this dichotomy has been very harmful to women. Has been very harmful to women and continues to do so. So there is a little bit of activism in this particular approach. Okay. On the 23rd of October, 1622, 2 Jerusalem men came to Sharia court to certify and register a contractual agreement between them. This document, and many like it, have survived as part of the tens of thousands of Sharia court records dating from the pre-modern Arab world, giving us rich information about the life that people led. According to this particular court record, the 2 men had agreed that Fatima, the daughter of the first, described as al-murahiqa, meaning teenager, was to be employed as servant of the second man, serving him and members of his household for a period of 14 years, in return for 14 piastres, 5.5 of which were paid out immediately to the father. 3 were to go to charity, and the rest to be held on account to pay for her clothing. If this was a singular case, it would not have been significant. But in fact, court records from Palestine contain consistent references to similar contractual agreements regarding young girls, some referred to as minors, while at least in one, the girl was 20 years of age. The contracts were recorded by fathers, brothers, and even uncles, who were presumably guardians of the girls. And in all these cases, the male relative contracting took the pay in advance and left the girl behind to serve for a number of years, extending up to 20 in one case. Zoom to the contemporary period. Dependence on the earnings of daughters continues, and similar patterns, if in new form, also continue. In Jordan today, conservative discourses call against the work of women, and yet fathers will permit daughters to work when they can remain in control of the daughter's wages. The same can be said for husbands who have the right, according to Jordanian law, not to financially support their wives if the wife insists on taking a job against his will. This has meant that Jordanian wives who work contribute their income to the family, which they, like other Arab women, did in any case. But here we see the law being deployed to control the woman's right to work, guaranteed by the Jordanian constitution. As for daughters, Jordanian fathers have been known to have them sign a loan deed at the bank, mortgaging their future wages against loans that the fathers cash in advance. Not very different from the 17th century practices discussed earlier. Other Arab countries have similar systems, with daughters working from early age as field workers, factory hands, or as domestic servants, with the father or brother cashing their pay each month directly from their employee or taking it immediately from the girl. As the girl grows older, it is the husband who steps in, and only when family ties become looser or there are children that we see the ties controlling her income loosen. Ironically, modern labor laws in Arab countries, as well as social discourses, confine women's access to what is termed hard labor, when in fact, research has shown that women have always contributed to hard labor. Domestic work is hardly fun and should be put smack in the category of hard labor. It certainly is not white collar or intellectual. In Arab countries where the work of women is widely accepted and girls work from a very early age as domestic servants in urban home, as factory workers, or as day labor on work shifts in labor-intensive jobs like breaking and carrying stones, mixing cement on construction sites, and brick making. While today we do not see the same patterns in countries of the Gulf, historically, it was women who undertook the setting up and dismantling of tribal tents, huts, and helped in the building of homes. They went out on pearling boats and in some cases actually dived for pearls. They provided the major labor for herding camels, watering and grazing, and took on jobs in the marketplace selling or shopkeeping. When discussing women's economic participation in Arab society, the example of Khadija bint Khuwaylid is usually brought up, and it is a good example. When followed, we find businesswomen like her existed throughout Islamic history, leaving behind them records of transactions and deals they enacted, buildings they built, awqaf they endowed. Some were dynasty builders, as for example, Asma al-Khalidi, whose name begins to appear in 1831 in an orchard transaction in Jerusalem court records. When her tracks are followed, we see her recording property, buying and selling, and enlarging houses and rooms she rented out, receiving income and reinvesting it. Randy de Guillem's study of waqfs in late Damascus in late Ottoman Damascus, tells us of gender blindness in regards to waqfs. These are religious endowments, and shows women as equal participants in the creation and managing of waqf endowments. Mary Ann Fay's study of Egyptian Mamluk households confirms de Guillem's study, showing women as endowers and managers of waqfs, a situation that gave them power within the Mamluk households and power structure. To endow waqfs, women must have been in command of property and wealth which they inherited, invested in, traded in, and worked to achieve. Control over her own money was guaranteed by Islamic law. At the other end of the spectrum, we find even middle-class and poorer women also striving to give something back to their communities by endowing small waqfs to their streets and corridors. Fariba Zarin Braf Shar has shown that 1/4 of urban property in Istanbul was endowed as waqf, of which almost 10% of all waqfs were endowments made by women of the middle and lower classes. Court records tell the story of women as craftsmen and traders in markets all over the Arab world. We find Jewish goldsmiths in Jerusalem, weavers, dayas, dallalas, who sold goods for other merchants or individuals for a percentage of the price. Going from door to door, they sold new and second-hand goods, clothes, fabric, footwear, headwear, cosmetics, household goods, tablecloths, etc. Dallalas were to be found all over the Arab and Islamic worlds. One can say that modern retail came at the expense of women, and that is not the only example of disjunctures in regards to modernity and women. Women also worked as beauticians and entertainers. They owned and worked grinding mills, produced and sold cheese and ghee, owned olive orchards, ran olive oil presses, and dealt in oil and soap products. In Cairo, we have mention of several ma'allimas owning and running coffee houses. The Tunisian historian Dalen Dalargosh reminds us of women sellers in the marketplace holding spots to sell vegetables or other items they may have produced themselves, like weaving or sewing, in which women were involved. Mention of mu'allimas controlling marketplaces or trade in particular items reflects similar, if not well-known, phenomena in Arab markets today. Court records speak of labor disputes and litigation involving women heads of guilds and women in the labor market recruited from the spot in the marketplace where women looking for jobs meet. In other words, women's work was normative, And today, the same patterns continue. We find women working in the fields, in the streets, in the marketplaces, in factories, in white-collar jobs, from ambassadors to company executives, professionals holding jobs as teachers, doctors, nurses, engineers, and women have even made a start as court judges and limited membership in the armed forces. They have yet to hold any positions as district attorneys, security officers, police, except as auxiliaries, to deal with women being interrogated or imprisoned. They have also yet to hold positions as ministers of any critical ministries like foreign affairs or internal affairs. Today, women constitute an important percentage of wage earners, and the number of women providing singly for their families is growing. Statistics show, for example, that 35% of all families in Egypt are supported by a woman, and the government promised to provide health insurance to 5 million peasant families supported by a woman. Okay. I began this presentation by discussing lived realities of women during the pre-modern period to make a number of points. First, significant research has been accomplished in women's history. Where once we depended on books of theology, fiqh, as a source to understand how women lived, it is now clear that fiqh represents an opinion, a discourse, usually a reflection of what members of a particular class, the ulama clerical class, consider to be the moral or proper way that things should happen, rather than the actual way that people lived. In fact, we can read theology or juristic opinions, fiqh and fatawi, and similar sources as indicators of the particular situations that caused unease in society, rather than as a historical record of how society lived. A question was brought up to a mufti's attention because there was a need for a response to a problem. The question itself tells us what is going on in society. Second, since most of the material I use is from Sharia court records, this also means that the law applied in court was based on the Sharia by ulama, and we do not see them passing judgments about women and work or women in the public sphere. This is very important, because many of the issues that are brought up today by Islamists regarding women did not seem to be the concern of Sharia court judges during the pre-modern period. Third, with this new research, it is not acceptable to continue with the same normative narratives and paradigms that draw lines between the modern and the traditional, that see women in the pre-modern period living confined in the home, limited in her choices, and living and dying pretty much as a companion, mother, and wife. One big problem with this image is the belief that this is what Islam decreed for women, that her life be limited to her home, which she only left according to need and only with her husband's permission. She was to work in the house, and only absolute need of the family allowed her to leave it. She did not work with men and covered her face among strangers. At home, she had no right to divorce and did pretty much what her husband asked her. Again, court records deny these points. Without doubt, Islamic society just about in every country was quite conservative, and the descriptions given by fiqh was widely accepted as how things should be, at least for the middle classes. Members of the fuqaha class were mostly of the middle classes, upwardly mobile and working closely with elites, and envisioned a life for their families that considered women's work as an indication of poverty and lower classedness. Hence, we do not see Sharia judges authenticating deeds renting out daughters or sisters condemning such practices, even though the transaction involved a young girl's move to live in a virtual stranger's house while her family moved away. The faqih may have problems with a wife leaving her home and give specific reason why she should do so, but this did not stop the faqih from officiating at a court case brought to him in which women came to dispute the rights to marketplace spots when very often these disputes involved men and even physical violence. Most importantly, records about marriage and divorce show women keen to include conditions that limit their husband's ability to take a second wife, move them from the hometown, quality of clothing, pocket money, and many other details. In the 1980s in Egypt, the inclusion of a law that described taking a second wife as harm to the first wife, thereby allowing her to sue for a divorce that ensured her of her financial rights, was fought and rescinded on the basis that limiting polygamy was against the Sharia. What this had to do with it being a hardship to women was not taken into consideration. Today, Khula's law, which was clearly a wife's right, never objected to by a qadi in the pre-modern period, is being fought by conservative groups wherever khula was passed, as in Egypt and Jordan. It should be noted that during the pre-modern period, khula was considered the wife's prerogative, and that modern law simply went back to pre-modern practices. So the positivist outlook that see women doing better under modern law is not entirely accurate, and one needs to see these changes from a wider, more comprehensive perspective. Fourth, and here I move to the nature of fiqh discourses. While the shape and nature of fiqh has changed, as has language from the medieval to the modern period, there are essential similarities, particularly when it comes to women. I do not say family, because there is no discourse on family in medieval fiqh, while family is a central discourse of modern fuqaha of every type, from the most liberal to the most conservative. Medieval fuqaha spoke of husband, wife, children, and marriage, theologized about relations between them. Family begins to appear in the 19th century with the introduction of French law, which considered the father the legal head of the family. I realize this is a difficult point to grasp, but it is essential. The modern state was interested in organizing society, and part of this was undertaken through legal codification and construction of power relations between it and society, as well as between different institutions and within these institutions. That is what took place within the new family cell, which was recognized by law and newly promulgated constitutions as the basic cell making up society. And within this cell, the father was recognized as the legal authority. We find remnants of the old system continuing in some societies where tribal power continues to be significant, such as in Jordan, where a daughter cannot receive a divorce without her father's approval if she is younger than 40 years of age. Don't ask me why. Father as legal head means he decides which school the child goes to, can arrange a daughter's marriage without a mother's say, or that rations and other state needs like family identity cards are all placed in the father's name. This, of course, follows the introduction of nationality, a new system for most countries of the Middle East, beginning with the Ottoman Code of 1859, which follows Europe's own new laws declaring that a woman follows the husband's nationality. While I'm not disputing the centrality of the father during the pre-modern period, it should be noted that the modern family is pretty much part of the modern state system and works for the benefit of this type of state, which I call the patriarchal state. The laws codified by the patriarchal state balanced out against that women made by holding on to fundamental and basic relations that constructed a system of inequality between man and woman. The introduction of what became known as personal status law is very much part of this new patriarchal system. A brand new term borrowed from the Italian language with a new philosophical approach that set up an order of things that defined human beings from within family units. Notwithstanding the claims that modern laws promoted personal freedom, that is not what takes place given the new grids through which human society was perceived, organized, and dealt with legally and otherwise. By defining personal status laws through natural qualifications, meaning male or female, minor or major, and through social needs like the state's responsibility to upkeep the family and its spousal of a moral discourse that sanctified and fortified the family, an unequal system that denied freedoms to part of society, women and children, which were placed in the hands of the other part, adult males became assured. In 1937, Egyptian court case defined the term personal status as follows. By personal status is meant the totality of what differentiates one human being from another in natural or family characteristics, according to which the law-based legal principles in regards to his social life, such as if the human being is male or female, if he is a husband or a widower, a divorcee, a father or legitimate son, or if he is a full citizen or less due to his age or imbecility or insanity. One should ask, how is this discourse similar to that of medieval fuqaha? And here is where we find important continuities. For while this construction is modern and the laws supporting it are French, biological differences actually had beginnings and is dependent on discourses from the medieval period, with the expansion of the Islamic empire and the internal growth of its institutions and the contradictions between what the Quran and Sunnah of the Prophet established during the early period of Islam and the development of ideas regarding issues of law and principles to guide jurisprudence, like maqasid al-sharia, these are the higher intentions of sharia, and in particular, hifz al-nasl, protection of progeny, is of special importance to women and Islamic law. Elaboration on the Quranic principles regarding inheritance, and particularly interest in developing a theology regarding hifz al-mal, that is protection of money or property, and its interconnectedness to hifz al-nasl. This process cannot be emphasized enough in its establishment of a gender philosophy around hifz al-nasl as a central concept of fiqh discourses and how they reflect on laws that were formulated in answer to the need to control the womb. Today, these laws constitute the basis for personal status laws in the books of Muslim countries that consider these laws stemming from, or at least based on, the Islamic Sharia, a formula which gives these laws immutability and almost holy sanctity. This means that fiqh discourse actually continues within the modern state, even though the very nature of family changes. The important point to make here is that we should differentiate between women and family, and the inclusion of both together in most legal codes in the Islamic world has been a method of denying women full citizenship rights. Seeing a woman as enjoying equal rights as a citizen is always limited by including a line according to the Sharia or language that may appear to be pro-women in laws that actually work against her. For example, ensuring that her family responsibilities do not hinder her job. These may appear logical and favoring to women, but what they do is actually keep women and family within the same discourse, focusing on women as mother, with primary duties. We never see the same type of language included in regards to men, and that should give us pause to ask, is the father not equally responsible for the welfare of his family? Does the law not give the father the legal authority over wife and children? Why then do we not see the same language tying men to the family? Thank you for your attention.